Hey, 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 self-storage. Welcome to Gabfocus. Today is our annual legal update. We got one of the best to deliver some awesome knowledge. But Melissa, how in the world are you? What's going on over there?
Fantastic. You've caught me home 1 week out of the month. I'm super excited to be here.
I know, I bet. Sometimes it's just nice sleeping in your own bed and not having
It
to
is.
do the road and eat healthy, a home cooked meal. Those are all
Yep,
things that we take for granted when we until we can't
absolutely.
have it.
Trade show food is the worst. Everything is fried and breaded, and yeah, it's bad. As
Yeah.
good as it is, it's not good for being healthy. So
It's good for the soul, is
yes.
how I would put it.
Yeah,
But
there you
y'all,
go.
welcome to this episode of Gap Focus. Y'all, if this is your first time here, you chose a really good one. This is our annual legal update, and there's been a lot of legal updates happening around self-storage so far in 2023. And I know there's going to be a lot of things happening heading into next year. But without further ado, though, let me introduce my friend, my awesome chief legal counsel, and the one and only Joe Doherty. Welcome to Gap Focus, my friend.
Great to be here again, Tommy. Thank you so much. And good to
Welcome
see
back.
you and Melissa.
Yeah, this is not your first time gracing the Gap Focus stage, and we appreciate your time. And I think honestly, it's just another show of your commitment to our industry and educating the people and keeping our businesses, our investments, and our customers safe. So in case the crowd, someone in the crowd doesn't know who you are and what you do, tell us, Joe, who are you and what do you do?
Well, first off, I'm a dad to five kids, and I've got a lovely wife who helped we raise those great kids together. And as I said in the lobby talk, they are big fans of the Storage Pug socks. So that's who I am first and foremost. But that's probably not why you came today. For purposes of this call, I'm the chief lawyer and lobbyist for the Self Storage Association here in Alexandria, Virginia, looking over the beautiful Potomac River today. Um, but I really couldn't do the work that I do without folks like you and Melissa and my colleagues here at the Self Storage Association and at all the state associations. I'm going to touch on that a lot today as we're talking about this. But I get to have the great job of being the spokesperson in a way, not officially, but in a way. But really, we couldn't do all the great work that we do without so many other people who I hope are listening in today and can hear some accolades for them as well.
I love that. Honestly, I do want to spend a moment doing that. I don't think any of our speakers have ever given the audience the accolades because, like, y'all spend over an hour with us once a month. And I see these names, and Phil. I mean, shout out Phil during lobby talk. Phil actually volunteered to pipe up and share his thoughts and ask his question live. So I think that's incredible. So thank you, y'all, for being committed to running and operating and investing your business the right way. And I know Melissa and I can't thank you enough.
I mean, there's 157 people on here right now.
Yeah, so welcome, y'all.
That's
And if
great.
this is your first episode of Gap Focus, again, you chose a good one. It's brought to you by our teams here at Storage Pug and the team at Lighthouse Storage Solutions. Gap Focus setup real simple. We're gonna go for about an hour. It's a live Q&A, and so because it's a legal update, Joe's got an agenda of things that we're gonna want to tackle. State level updates, challenges, sticking points, what to expect. And as we can already see, there are already 10 questions in the Q&A. So we're going to make sure that we have time to cover those questions live. So without further ado, I want because I get to ask the questions. I'm going to ask the first question. Christine, Christine, I saw you posted on the Gap Focus Friends Facebook group earlier, and you saw and were jealous at my legal review mailer. Joe, how do the people get access to this if they don't already get this thing mailed to them every month or every other month?
That is an exclusive member benefit of the Self Storage Association. My colleagues Carlos Caslow and Daniel Bryant are primarily the ones who write that. I write a little bit here and there, but those are your guys on the Self Storage Legal Review that comes out every other month, and you have to be a member of the Self Storage Association to access that. So we could talk about the association a little bit more later, but that is a great exclusive member benefit, one of the many of being an association member.
There you go, Christine. There's your answer. So be part of the National SSA, be a member. And this is one of dozens of awesome benefits. So Joe, thank you. And shout out to Carlos and Dan for putting this together for everybody. All right. So Melissa, do you want to kick us off?
Yeah, let's do it. We're going to start at the state level here, and we're going to talk about changes. What overall changes do you see trending at the state level, and are any of these trending through an entire region?
Yeah, so Melissa, that's a great way to kick off the conversation. I know you in Louisiana, Tennessee are familiar with a lot of the changes we've pursued over the last, mainly over the last 10 to 15 years, although our self-storage legislative program's been around for about 20, initially under the leadership of Tim Dietz, and then over the last 5 or 6 years, I've been leading up that group. But traditionally, it's been focused on things like eliminating certified mail requirements. That's almost universally adopted if we're talking about trends across regions. Same with optional towing, almost universally adopted in online auctions as well. Our focuses more recently have been on making sure we can finally eliminate newspaper advertising across the country. It's over 30 states now, so it's a lot of states where that's been accomplished, but it remains a challenge and sticking point in a lot of places. And then more recently, we can get into this a little bit more as the conversation goes on, but it's been property tax reform has been a focus over the last couple of years in a few different states. And I've got some exciting news to share. I won't give that up quite yet, but later on in the conversation, I want to share about some of the other items we're looking at to tackle in the future.
Okay, I'm excited. Planting seeds already.
Yeah.
So on the flip side, beyond what's the changes that are trending, what are some of the legal challenges that you're seeing that people are facing at the state level?
Yeah, so I kind of put that into two different categories, Tommy. There's the, to use a Donald Rumsfeldism, there's the known knowns. There are the efforts to change the lien law. We see those come up in at least one state every year. Well, tenants need more time. Tenants need additional notices, things along those lines. We also see sales taxes. We see challenges on property taxes in the opposite direction. So California, a couple of years ago, tried to eliminate one of the best property tax systems in the country, and self-storage was at the tip of the spear to defeat that in a ballot measure. So those are kind of what I'll call the known knowns. But then you have these unknown unknowns of, yeah, we sort of vaguely know there's going to be something that comes up from a challenge or a defensive measure, but we don't know exactly what form that's going to take. And I'd be happy to touch on some of those, because you can just really get pretty zany pretty quickly with those defensive challenges.
Okay.
Do you see any of those that, like, I guess the known, amongst the known, do you see any of those that are the quickest to gain traction, or any one that jumps out that we should all be the most concerned about? And and maybe some of this other, talk a little bit about rent control legislation as some of the challenges that have been, as one of the challenges that have been propped up in the last 18 months.
Yeah, so I'll touch on the rent control in a minute, but in terms of the ones that really concern me, it's been a couple that have come up in New York State and New York City, and I'd actually put those in the unknown category. The one in New York State, it's a proposal to mandate that every storage facility install separate lock boxes within every storage unit for tenants to store sensitive documents, passports, birth certificates, things of that nature. And then the lien would not extend to those items. So if a tenant doesn't pay, you can't sell them. Not that those items necessarily have value, at least not in a legal way, but they might be reason why someone is keeping that unit, and then you can't even charge them for that space, so you're essentially giving it away for free. It's just kind of
Mm.
I'll say disconnected from reality, and just not the business that self-storage is in. And then the second one in New York City that really concerns me is the and we can talk about the rent control piece of it here in a minute, but the other two pieces of the legislation are banning all late fees. So we're the folks on this call are familiar that in many states, about 40 of them, there's a late fee safe harbor of $20 or 20%. New York City would say you can't charge late fees at all. Any time, any reason, you can't charge them. And then the other piece of the proposal, the more concerning part, is that you can't get rid of a tenant for any reason other than non-payment. So we can everybody on this call has a story of a troublesome tenant. Somebody living in a unit, somebody's Hannibal Lecter or Walter White, or any number of other troublesome Hollywood self-storage tenants, and you want to get rid of them, but hey, they're paying their rent, so you can't. And again, just really
So
divorced
totally
from
disregards
reality.
all the rules and regulations that you have spelled out in your lease agreement. Basically, it's just, I'm going to collect rent and that's the only thing I can do from you.
Yes. Yeah,
Wow.
just it's that simple, Melissa, and it's crazy. But one of the reasons we exist as an association is to educate legislators and decision makers about the consequences of their decisions. I think in a lot of cases, these lawsuits or excuse me, these pieces of legislation are coming from anecdotes and it's really dangerous to govern by anecdote. But
Mhm.
as an association, it's our job to go to these legislators with our local folks and say, let us help you understand the industry a little bit better. And I would say in most cases, we're able to address the concerns that gave rise to that legislation and put a lid on it.
Yeah. I mean,
Wow.
you bring up a good point with those anecdotes. I think like those anecdotes often come from operators who aren't operating correctly, and it causes
Yeah.
a ripple effect downstream, right? And I think that's that in itself is an anecdote for all of us to be operating better and make sure that we
Yes.
are doing things the right way, by the book when possible, right? But I saw a comment by Robert here in the related to the ban. Is the ban on late fees, is that specifically for self-storage, or is that businesses in general? Do you know more details about that one and about that ban?
Yeah, so that everything I was just talking about is specific to self-storage.
Wow.
So this isn't just, hey, storage ends up getting swept up into something bigger with unintended consequences. These are directly at and only at self-storage.
Okay.
And you're right, Tommy. So much of this does come from bad operators that make bad decisions, and that creates the reason behind some of these legislative efforts, which is more reason why we should all be trying to, even get our competition in your area, get them to join your state associations, because the more educated we all are and we're all operating the same way under the laws that National SSA has helped us create, we're all safer. If you've got someone out here going rogue, that's when, problems happen. And so Joe, I remember, 10, 15 years ago when the spreadsheet that you guys would show us at the national meetings would have huge holes in them. Like, well, we've got, this many states, and we've got the late fees addressed in these areas, but these 10 states still need it. And you guys worked so hard and so diligently for so many years. And like you said, most states now are pretty uniform in those big key pieces of our lien law, which is fantastic. Kudos to you guys and your team. But what areas now are you guys focusing on? Since you've pretty much shored up those things, what areas really have your attention?
Yeah, it's among the traditional items, Melissa. It's really the newspaper advertising. There are still about 18 states that have some form of advertising. So whether that's one ad required or two ads required, it's whatever it is, it's a complete waste of time. So continuing to focus on that. And then
Right.
the property taxes as well. I get a lot of questions about lien processes and what do you have to do? Why do I still have to advertise in the paper? Things like that.
Mhm.
But the question we get most frequently is, my property taxes are completely out of control, and what can you do about it?
Yeah, I know
And
I've had that conversation with you
yeah,
myself.
yeah, exactly. So
Yeah.
that's something we're looking to bring that solution to some other states. We passed some really great legislation in Indiana a couple of years ago,
Yeah.
and then some follow-on legislation this year in Arkansas and Idaho. And all of those, I'll say this over and over again, all of those were member driven. It was not the association driving that. We certainly had the relationships and the knowledge and all of that, but these would not have been accomplished without folks like Brandon Harnish in Indiana, and then Dan Lusk and Bill Humble in Arkansas, and a bunch of really good folks, including Ron Osborne in Idaho. We would not have been able to accomplish this without them. It's very much a member driven issue, unlike some of the other items where we can go with our local lobbyists and say, hey, this statute's antiquated, and kind of
Mhm.
move things through ourselves. But property taxes are very much member driven.
Okay. Okay. Squeaky wheel.
Yeah.
Yeah,
That's
Yeah.
exactly.
that's exactly right. And
Yeah.
we can say, hey, the data show this, but if you have, and they might say, okay, yeah, they hear that, legislators hear that all day, but when they have one of their constituents in front of them saying, hey, my property taxes were X 2 years ago, and now they're 100% of X, 100% above X, then yeah, they're going to listen to that.
That's a problem. Yeah.
Wow.
So on the newspaper, since there's still so many states that need that legislative change, are there certain states that you're really focused on? Because like if we can get these to switch over, then it'll impact the ones around it.
Yeah, Melissa, that's an awesome question. So the biggest one that I'm most happy about this year is California. That's been probably 15 years in the making, dating back a long time for us. But we've got a great relationship with the California Association, and this year we're able to work through not completely eliminating it, but from moving it from 2 to 1, which is going to cut costs in half.
Yeah.
And then California had this weird requirement that you have to publish the ad in the public, I want to make sure I'm saying this right, public notice district where the facility is located. And I'd heard from a colleague of mine who had been the executive director in California, and the state can't even tell you what the judicial notice districts are. She said she went to a clerk's office once, and they literally rolled out an old map and said, well, here they are. And she said, is there a copy of this somewhere? No, you can take a picture if
Oh
you want.
my goodness.
So we were able to change that to allow advertising in the county. Obviously, you know what county you're in. And
Right.
then finally eliminating the requirement of describing the property in the ad. So
Wow.
many of these happen online now that you don't need to describe the property, you just look at the photos. So
Mm-hmm.
that was a big one. And then the other one we accomplished this year was in Rhode Island. Moving Rhode Island is unique. It's the only state in the country that requires advertising specifically directed at the tenant. So it's not even of the sale; it's advertising the debt, and they required 3 ads to the tenant if you can't show that the tenant actually got the notice you sent to them. And we were able to cut that down from 3 to 1, and we're hopeful to go back this year and completely get rid of that.
Okay.
And then finally, Florida. That's been one. I think Florida is a potential key to the rest of the Southeast, like Georgia, South Carolina, that still have this advertising environment. And that one. I feel better than I've ever felt about it. But Florida is just as politically conservative as of a state it is. The newspapers also have a lot of sway there, so that'll be our biggest newspaper priority in 2024.
Okay, I know
Awesome.
there's some Floridians in this group, and I know they are cheering you on.
Yes,
Yeah.
I am one of you by background, so I am cheering us on as well.
There we go. That's so. I mean, so you mentioned some specific states there, like the Rhode Island, the Floridas of the world. So like, which of the states, when it comes to laws around self-storage, do you find to be the most supportive? And on the flip side, which ones are the most or the least supportive or the most prohibitive when it comes to running and operating a storage business?
Yeah, that I would say just kind of initially, all of the laws generally follow the same format generally, and there are definitely some differences and some pretty big differences in some places, but it's some number of notices after the tenant's been late for some amount of time, and then you have to wait a certain amount of time after that. Then you advertise, whether in a paper or online, you wait a little bit more time and you have the sale. Generally that's the format. So all of the laws are very favorable in the sense that you don't have to file a lawsuit to enforce your rights. This is something that came up in Louisiana a couple of years ago. I know Melissa remembers it, where a state legislator filed a bill to try to eliminate the lien remedy and put all of these issues into court. And we were able to say,
Imagine.
hey, that's just crazy. You have no idea what you're getting yourself into if you do that.
Yeah.
So with that said, the states that I would say are most favorable, probably not terribly surprising, states like North Dakota, Montana, Iowa, all very favorable. Nebraska is another one. In terms of the less favorable, New Mexico has the longest lien enforcement period in the country at 90 days.
Wow.
And also Minnesota, which has both an extended enforcement time period, but a whole bunch of requirements, probably about 15 separate requirements of what needs to go into a rental agreement. And then Minnesota has, I want to say, a unique, or maybe one or two other states have this type of provision where the tenant can get access to property even when they're in default. So there are certain items that the statute says, like personal papers, what they call tools of the trade. So I'm a carpenter and I've got a hammer and a saw, that type of thing. I'm not a hands-on type of person, so I don't even know what someone might have, but you know what I mean. Yeah, so they can get access to those items up to a certain dollar amount, even if they're not paying you. So that's a provision that is not going anywhere. We're just trying to kind of be the little Dutch boy, keeping our finger in the dike and not making it any worse.
All right. So do you see any new changes coming about through the end of this year? What do you see?
Yeah, so the biggest one is going to be the effective date on that California bill. See, the California operators can start using that on January 1st of 2024. But most of our activity is really between, say, January and June. Couple of stragglers on the back end, depending on the state. And then the laws themselves, you can start using them within about 60 or 90 days after they've been passed. So we're through most of those. California's the one outlier, as it is in so many ways. Some good, some not so good. But the California operators on this call, I'm sure will be pleased to start using that at the beginning of next year.
That's awesome.
That is really cool. So I guess let's shift gears and dive deeper into some of these challenges that you preface at the top of the call, right? So what are some of the toughest legal battles or legal challenges for owners and operators that you see happening right now?
Yeah, so let me just touch real quickly on the rent control issue, Tommy. So that's not a legal challenge necessarily, but it is something I think we all need to be concerned about. And again, these are things that come up by anecdote. We first saw this in, of all places, Hoboken, New Jersey, probably 3 or 4 years ago, and thought, oh, it's a one-off type of thing. We'll probably never see that again. And then just this year, both in Texas and in New York City, there were rent control measures, again, directed specifically at self-storage. This wasn't something like that was at all real estate sectors or anything like that. It was specifically at self-storage. And thanks to the good work of folks like Ginny Sutton down in Texas and the New York Association, led by James Coakley, with our assistance, there as well in bottling both of those up. And it's scary type of stuff, because we all know fundamentally that self-storage is a month-to-month relationship. That's what's so great about it for both the owner and the tenant. And if somebody doesn't like the rent that they're being required to pay, they can move to another facility. They've got other options on a month-to-month basis. You're not talking about somebody who's locked into a long-term lease and they end up getting bumped up midway. And fortunately, that argument prevailed in both of the states. In both, New York City's not a state, even though it thinks it is. But that prevailed in both New York City and Texas, and I'm hopeful that that issue will not come up again. But I'm also sufficiently aware to know that we probably have not fought our last rent control battle.
Frustrating that so many things just seem to be storage focused, that
I know,
that get
like,
these attention.
we've been operating behind the scenes for so many years, right?
I
And
know.
now all of a sudden we're getting, I don't want to say attacked, but targeted bills that are directly calling out our industry, which is I guess that
Yeah.
in itself is a challenge. That's new, right? Or it's a new challenge that we have to face. And I think that
Mhm.
goes back to the lobbying comments of, like, we have to have our people in the places to educate these legislatives, these people making these laws, who may or may not know the impact or the implications of the laws that they're even making. So
Right.
that's really incredible. So one more question related to that rent control. So, like, generally, do you, like, what are the root causes, or what's the anecdotes, or where are these seeds coming from that's getting into these state senators and going all the way up through the ranks there? Like, what's actually happening in New York and Hoboken and in Texas?
Yeah, so let me use Texas as an example, because I think it's instructive of how these things come up. So of all people, the complaining tenant was an aide to a state representative in Texas, and she convinced her boss to draft this legislation passing rent control, trying to pass rent control on the self-storage operators in Texas. It comes up that way. It might be a legislator, him or herself. It might be the aide to a legislator, or some constituent who complains to a legislator about this issue. Those are usually the way these things come up, and it can literally be one complaint, and that's what it was in Texas. It was one person who happened to be in the right spot complaining about a rent increase that she had received from a storage operator down in Texas. And then ironically, she moved to a different community and rented from the same storage operator. So it's a question of, well, how much of a problem did you really think this was if you went and rented from the same people? The great
Yeah.
thing in a lot of ways about Texas is there's a ton of competition. There are something like 6,000 facilities in the state. So she easily could have rented from someone else if she felt so hard done by. But it's really as crazy as that somebody just
Well,
in the right position
Wow.
knows the right person can get a bill drafted and force
because
us.
they don't like something.
Yeah,
Yeah.
exactly. I mean, yeah,
Mm.
I think a lot of times, uh, at least I like to think that legislators are coming at this from the right way. They're trying to help people, even if they don't fully understand what they're doing. But then there are other times when you look at it and say, oh, this person just wants some benefit for him or herself.
So I have seen conversation about the rent control issues, questions and stuff come up online, and people have frequently commented about, some of the REITs that will do that really low bottom of the barrel rate to get people in, and then jack up their rate 60, 90 days after that. And of course, you got smaller operators that are saying, we can't do that. Like, we can't afford to do that. And we don't want to give ourselves the bad name that some of the bigger boys have. And is this not just playing right into the hand of the argument about rent control? Because it kind of seems kind of seems a little underhanded to rope someone in at such a low rate just to turn around and double it, 60 days out. So does that have that kind of an impact, or were these conversations not anywhere at all related to what the REITs are doing with their pricing?
Yeah, not related. These really just came up honestly by anecdote. It wasn't something that was in the view that this was a persistent issue. I think in New
Okay.
York, it was one person complaining. In Texas, I think in New York, we ended up seeing some background from the legislator that introduced the bill that it was maybe one or two tenants complaining, not even about rent increases. We didn't even know where on earth the rent control language came from in New York. It was some tenants complaining about having been locked out, and then somehow that led to rent control. So
Okay.
yeah, it doesn't seem to be tied to any specific pricing practices.
Okay.
Rather, just kind of in the Texas case, just one person who happened to be in the right position to try to influence legislation.
Okay.
Wow. Well,
All right, then. Well, let's talk about some pitfalls. What are the most common storage legal pitfalls that you see?
Yeah, so they're far and away wrongful sales. So we monitor the dockets, the new cases that are filed on a day-to-day basis, and not all of them. There's definitely some variety out there, but by far and away, the one that we see most commonly is wrongful sales. We certainly touch on some of the practices that you can do to avoid those, but I know we hear a lot about other issues that can come up. Talk about ADA, talk about things like cashless bans and other things of that nature. Those are certainly a concern in some ways, but wrongful sales are by far the biggest issue that I think the folks on this call need to be concerned about.
wow. Well, on that to that point, the very first question that was submitted, shout out Melissa Mueller for sending this one in. But it's kind of related to that, right? So if you've evicted a tenant or they're in their lease for any other reason besides delinquency, right? What do you do with the stuff that they leave behind? Do you turn around and go through the auction process? Or do you dispose of it? What's the correct action here so you don't lead to another type of wrongful sale situation?
Yeah. So Tommy, here on the agenda that we'd put together for this call, one of the questions was, what are some of the toughest legal challenges for owners and operators? And you've hit exactly on the one that I had jotted down for that. It's these what I'll call troublesome tenants. Somebody they're paying you, but perhaps they're harassing your manager. They're living in a unit. They're doing any number of other illegal or things that are in violation of the rental agreement. And what do you do with those folks? So the first step that I recommend is send them, or literally hand them, a notice of non-renewal. I know there are some folks in the industry who say, well, what's the difference between non-renewal and termination? I have a concern that if you terminate the rental agreement, that you potentially eliminate your lien rights. Not everybody shares that view, but that's my view. So again, these are month to month. Just say, hey, we're not renewing you for the next month. And then depending on the severity of what's happening, if it's somebody living in the unit, I say cut off that person's gate and code access and overlock their unit immediately, and say the only reason you're coming to your unit is to take a staff escort and clear out your property. And then if the tenant doesn't respond or doesn't clear out their property by the date that you've given them, you are now in the world of eviction. Because it's not a payment issue that you deal with through a lien remedy. You have to evict them. And for the most part, there are some states that allow for what's called self-help eviction, where you don't have to go to court, but you typically have to go to court to evict somebody. And the biggest thing you want to make sure you're asking for from the judge is what to do with their property. You can get rid of the person, make sure they're no longer a tenant, but what do you do with their property? and you'd want to ask for permission either to dispose of that or to sell it. But that, I actually think this is a good segue. We're going to touch on this a little bit later in the call, I think, as well. But one of the new legislative items we're looking at tackling and starting in 2024 is specifically putting into state law how self-storage owners are supposed to address this very situation of somebody not moving out after the lease has been non-renewed or terminated.
Wow. So, I mean, along those lines, Joe, like, what are some of the other, common legal mistakes that you see time and time again people are making? Like you said, you're watching all these dockets of these, the lawsuits that are coming through. What are other common mistakes and errors that operators seem to be making?
Yeah, the big one that I see, not necessarily through the dockets, but just from conversations at state meetings and talking to folks when they call up our association headquarters, is, are you going cheap on your rental agreement? And this is not by any means a sales pitch for me, because I don't draft rental agreements. It's not part of my job. But please don't hire your brother-in-law who's a criminal defense lawyer to write your self-storage lease. Don't even hire the guy who might know, or gal who might know about rental of stores or apartments or commercial space. Hire a self-storage attorney to draft your rental agreement, and don't go cheap. You have a multi-million-dollar investment. Spend a few $1,000s to make sure your rental agreement has what the state requires that your rental agreement must have. And in many cases, if you're a member of a state association, I think Louisiana is one of those, with Melissa here, and you can get your rental agreement through the state.
That's
so you
the
have
cheapest way you can go.
Yeah. Yeah, so you have a lot of options,
Yeah.
and if you want something that's tailored, you can pay a little bit more. If you're comfortable with kind of the off-the-shelf option that's been vetted by a self-storage attorney, you can purchase it through your state association. But please do not go cheap on this, because it is the gateway to answering so many questions and issues that might come up at your facility. If you have a properly drafted rental agreement, it's going to cut off so many problems.
Yep.
Wow,
Exactly.
incredible. And if you're in Texas, and there's a bunch of states that have like official like signed off agreements, and if you're not using one of those at a minimum, that's, you're missing out on, well, one, protecting your business, but two, a really killer resource.
Yep.
And a lot of the states have leases that you can import into whatever software that you're using. So like, just make sure that you're using all the resources at your disposal. And it starts, like we talked at the top of the call, join the national association, join your local or your state association. So you're gonna get that theme throughout this and the rest of this conversation.
Yeah, for sure. I mean, we've worked hard to make sure that the lien law is favorable and fair. And if you don't have a lease agreement that supports the lien law, then you're not doing yourself any favors at all. So yeah, join your association and get the lease.
And get the lease.
So that's the most common legal mistake. But what are some of the smartest things that you're seeing owners and operators do today?
Yeah, so Melissa, I think it fits into the comment you just made. It's belonging to your association, and not just belonging, but going to the events. There is a legal session at pretty much every state and national self-storage event. And in terms of learning about legal compliance and the issues that we lobby on, going to those events and really soaking in that information, the self-storage legal review that Tommy had shown us earlier, any number of other resources that we have at the state and national level, you can't beat the value. And I think this is something I do have a vested interest in, but I really mean it when I say that it's the folks who are willing to learn. And we have so many. I see so many of the same operators hungry for information at our state and national shows. It's those folks that are going to make sure that their businesses are legally compliant, they're doing the right thing. And I would encourage anybody who's in that category, please encourage the folks nearby you, if they're not members of the association or they're not coming to events, to come, because I don't know how many times I've heard from new members to the association, "Oh, I've never had an auction. I thought I could just throw out people's stuff," or other comments like that, or my rental agreement is basically written on the back of a restaurant napkin, or
Mm-hmm.
how many times do I get the question about, "Oh, I just took over a facility and yeah, I don't even know who's in half of these units because the old owner, just kept it on index cards and
Mm-hmm.
he lost them, or he never had them," like that type of thing.
Yeah. Or the
So
index card has 5 different names on it.
yeah, exactly. Yeah, we all know this story.
Yeah.
So yeah, just making sure you're staying up to date on on all the new legal information that's coming down, and there's something new literally every year, certainly,
Yeah.
if not every month or two.
Yep.
Yeah, that is. So
Awesome.
be smart, y'all. um, so let's look ahead for a little bit here, right? So Joe, like looking forward, what new challenges are on the horizon heading into 2024 and beyond challenges? Like what are some good things that might happen also?
Yeah, so in terms of challenges, the first that really jumped to my mind are a bill in Georgia that is a defensive bill. It was filed pretty late in the legislative session last year or this year, but it's going to carry over to 2024, and it's frankly just a kind of catch-all of every possible complaint somebody could ever have about self-storage. So it's trying to regulate insurance. It's trying to regulate disclosures given about pest control or pest infestations. It's trying to change the lien remedy. It's I will applaud the people who wrote it because it's extremely thorough, but it's also one of these that you really wonder where it came from, and we've not heard any explanation about it. But that'll be a challenge we'll have leading into 2024. And then the other one, as a lawyer, this is a little hard for me to stomach, but we're going to be fighting the Florida Bar Association. They're the association for lawyers in over a bill relating to the sale of vehicles. So I know most operators use the tow remedy when they can, but the Florida Bar Association is trying to make it much more difficult to sell a vehicle in the state, and trying to change how our lien rights operate. And if you're not able to tow, then you're going to have a much more difficult time selling a vehicle if the Florida Bar gets their way. So I'm going to be fighting my own association of in my profession, but I think we're up to the task. We're able to defeat that earlier this year, and hoping for the same outcome next year as well.
Wow, so you're gonna fight the bar association. That is a
Crazy.
you would think
It's
that's
like a daunting task.
I know.
Yeah,
I'm trying
those
to think
meetings
what a
are really
metaphor
long.
would be.
Lawyers like to talk.
Oh
That's
my gosh.
crazy. I can't even like, yeah, I'm trying to think what a similar situation might be. And it's like you're literally going against the association made for people who run that association. Like what? What
So
what
aside from that one, how does the legal outlook look for 2024 besides the fact that you have to go against the Florida bar?
Yeah, so we're really excited about 2024. In addition to the defensive fight in Florida, as I mentioned earlier, we're gonna, I hope, finally get over the hump on eliminating the newspaper advertising requirement there. And then we're looking at a few other new legal issues or legislative issues to bring to some other states. So again, I'm the person who gets to talk a lot about what we do, but one of our big thinkers is my colleague Daniel, and we've been working through a bunch of different issues and talking to operators. And I'm excited to announce to the folks on this call as well the main new legislative issues we're looking at. First off, that how to deal with a troublesome tenant who doesn't leave when you tell them to. That's going to be probably priority number one. And then a couple other priorities we're looking at are, I know an issue that many operators deal with is, what do you do when a tenant doesn't sign a new rental agreement? You take over a facility, maybe you amend your rental agreement in response to a lien law like was passed in Louisiana a couple of years ago, and then you have these tenants who don't sign. What do you do? So we're looking to address that. And then there are a handful of states now that have a low value disposal provision in their lien law that says you don't have to have a sale if the property's under a certain dollar amount. South Carolina's $300. Maine goes up to $750. I think Washington State's $300 as well. We'd like to see to expand that to some additional states as well to just avoid these situations where you have to sell a unit when you know it's going to get nothing or next to nothing, and just clog up your inventory for that much longer. I would certainly not recommend folks overuse that type of protection, but it's going to be something that you can use in, I would say, really the extreme cases where it's like, okay, that's a broken end table and a moldy mattress. Nobody wants to buy that. Let's just throw it out and move on.
Right.
Wow. Holy
Oh,
cow.
I like that.
Yeah.
But I would encourage the folks on this call, if I can give people some homework, if you have any reaction to any of those items, or there are other items that you commonly deal with, we'd love to hear from you and see what type of legislative solution we might be able to come up with. Things like tenants who've passed away as another one we've talked about, or how to deal with if you have trespassers at your facility, people who just store stuff and you literally have no idea who they are, or non-monetary default on vehicles, like say somebody parks 2 vehicles instead of 1, or they've got a junker there but they're paying you. How can you deal with those type of situations? So those are just a couple other examples. But if folks have any thoughts, my email is going to be here in the chat. I think Melissa put it in already. We'll put it in again. Encourage you to just reach out to us and let us know, and we'll see what we can come up with in terms of a legislative solution.
Fabulous. So before we jump into live Q&A, and there's a lot of Q&A, is there anything else that you wanted to make sure that you communicated with the crowd, Joe? Was there anything else in your notes that that you would be remiss not to share?
Yeah, I just want to emphasize on the point of association membership. Just hit on a couple of legal items that we have as an association. Those include the self-storage legal network with Carlos Caslow and Scott Zucker. Those guys are a lot smarter than me, and you can call them up or email them and get your common legal questions answered. Then we have a whole website on our National Self-Storage Association website called the Legal Resource Center, where you can get just a ton of legal information for the industry. And these are member exclusive, and you can join the association really at any time. But we're currently promoting membership through the beginning of the next membership year, which starts on December 1st. So I'd really encourage people to join the National Association if you're not already a member, or join your state association. It's this is going to sound geeky of me, but I was a history major in college, and literally 200 years ago, when Alexis de Tocqueville came to America from France, he wrote a book, Democracy in America. And one of the items that he pointed out that was unique about America compared to the European continent was the existence of voluntary associations. And I like to kind of think we're in the history of that, 200 years later, in promoting voluntary association membership. So it's voluntary. We're not going to twist your arm, but you're making a mistake if you're not a member.
I like it. I would second that on the state level.
100%.
So, yeah, absolutely. Take advantage of that education and those resources.
Yes. So I just posted 3 links that are related to everything that Joe just talked about: the self-storage info on the self-storage legal network, the legal resource center that's posted by the National SSA, along with the digital archives of all of the legal reviews going back to, I don't know how far it goes back, Joe, but it goes back a ways. So you can kind of see the progression of what's happening with our industry. Yeah, it goes back to 2014, so about 9 years worth of data, or 10 really. Joe, that's incredible. Thank you. And you got, anytime we can shout out the associations, we will, from the
Yeah.
top of our lungs. So let's shift gears into the Q&A. I'm just gonna, Melissa, I think we can just sort by oldest and just kind of go through.
Yeah, let's
Uh,
just start at the
yeah.
top.
So Spencer, I think you were just, I don't know that yours was a question. Yours might have just been sharing data about the main laws there. I don't see a question, so I'm going to skip yours. But if there was a question, just re-ask it in question form. uh, but shout out Lane. She asked a question for someone who couldn't post here. So question goes, Joe, we are currently preparing to build a new climate control facility. However, our city can't figure out if we need fire suppression or not. Our plans are for 2 buildings, each of them so and so square footage. Our architect drew them purposely less than 10,000 square feet so we wouldn't need fire suppression, aka firewalls, sprinklers. I have been looking at the 2018 fire codes and the 2021 international building codes and can't really see where climate control falls into that. Is there a specific place under section 903 that this would fall under? Our city is thinking we need sprinklers no matter what the size of the building is. This is a significant cost and we would like to avoid if we can. So I think to summarize here, guidance on sprinklers, fire suppression for climate control buildings.
Yeah, Lane, I'm glad you asked that question, and thanks, Tommy, for reading that as well. The another item or area that the Self-Storage Association gets involved in is modifying building codes. So just the 30-second elevator pitch is building codes are not written by individual states and cities. They're written by, of all people, associations, and then passed on to states and localities to adopt. And we started influencing that process probably about 6 years ago. And we've been involved in the exact issue that you're talking about. So what it may not apply to your facility because your climate control, it typically applies only to facilities without indoor corridors. But I would say let's talk about that a little bit more. If you can send me an email, I can send you some information with a memo that we have that you can then provide to your local folks to see if that might be able to help you. The answer is a little bit more nuanced than that, but I want to provide some more time for other folks to ask their questions as well. But and I would just say to other folks who are developing, we have a number of other memos and issues we've addressed over the years on HVAC requirements, restroom requirements, building heights, etc. So if there are ever any questions you have about code related issues as you're developing a facility or considering a development, let us know and we'll see what we can do to help.
Awesome. Great question.
Okay. All right. Ready to get the next one? I've got one here from Jenny. This goes back to those unsigned contracts. My biggest fear this year has been having a previous tenant come after us whose unit was sold at auction, but we didn't have an actual lease on. I took over management of a facility 17 months ago, and there was a bunch of unclaimed units with no contracts, no ties to anyone. I sent 3 notices to current and past tenants with no response, so we auctioned the units. My fear is someone coming back and to turn it into something big.
Ooh, we all have those
Yeah.
if anyone worked in the restaurant industry, like I was a server when I was in college, you have these server nightmares. This is probably a self-storage manager's version of that nightmare where it just it's always on the back of your mind. Did
For
I give that
sure.
lady her iced tea? So,
Oh
so
my
Joe,
goodness.
what's the move here? What do we do?
Yeah, Jenny, I'll cut to the chase and then kind of work back from there. Ultimately, when you end up with these situations, you've got it typically turns on a business decision, and it is probably the right decision to have auctioned those units. It sounds like you did everything you could to try to track those people down, and you were unable to. The one other item I might add to this to give yourself a little bit of additional protection would be when you're communicating with those people you believe to be tenants. I would say send a rental agreement and and let them know if the rental agreement goes unsigned for 30 days that they're going to be bound by it. So that will, I hope, do one of two things: either bind them to that rental agreement or get them to call you up and say, why in the bleep are you sending me this rental agreement? I'm not your tenant. So I hope that helps out, but I think you've done everything that you reasonably could have done. The other piece I might add, you probably did this, is to just document the file with every single thing you've done, and hope for the best. There's only so much you can do. You could try to evict somebody like that, but you're gonna typically just spin your wheels and spend a lot of time and money on something that's unlikely to give you any additional benefit or peace of mind. But that would be another option as well.
Great advice, Joe. Jenny, great question. Hopefully you can sleep a little better at night over there. Sam Charouz, good question here too. I have a tenant in Maryland. He owes us a lot of money for storing the machines here for his business. Can we auction any of it off? The owner says they do not have a lien on the equipment, but his lawyer says he does. What is the next step?
So, Sam, if I'm understanding your question right, you're saying the lawyer himself has a lien on the on this tenant's property, or maybe the lawyer for the business. At any rate, what I would recommend is sending the lien notice to that person, and also checking what are called the UCC, the Uniform Commercial Code filings for that state. It's typically stored with the state Secretary of State. I know that's kind of duplicative, but the Secretary of State for the state of Maryland would typically control those UCC filings. And you can search by that tenant's name. I'd also search by his business if he's storing on behalf of a business, and see if there are any lien holders on that property, and then communicate to those folks. Another piece I might add, and I think this kind of goes back to the rental agreement that we talked about earlier, making sure your rental agreement's airtight, is you want to make sure your rental agreement asks for any lien holders. And so that would be another piece of information that might help you out as you're going through this process. But excuse me, ultimately you can sell the property. You just want to make sure you're communicating with those lien holders. And then if one does show up, you're going to need to work to get that property turned over to that person. We can talk. I'd say we talk offline about any more detail on that. But those are kind of the general steps that you want to take.
Great advice. Yeah, Sam, the Joe's email has been in the comment section, and if you need it, shoot me an email, Sam, and I can get you connected directly to Joe. Great question.
Yeah, and just real quickly, Tommy, I see that Sam's saying the business is in Maine. Do I do the search there? Yeah, go ahead, do the search in Maine, and also do the search in Maryland.
We can't have a legal discussion without asking about dead people.
Eek.
So, regarding deceased tenants, what do you do when some heirs of a deceased tenant refuse to sign an agreement indemnifying the storage facility from any future legal claims?
So, Eileen, I need to know a little bit more about the situation, but you typically wouldn't be able to require them to sign that agreement to access the property of the deceased person. But you would want to make sure that they are, for lack of a better phrase, who they say they are. So that would either be them demonstrating to you through court documents that they are the administrator or the executor of the estate. The language is a little different from state to state. Or that they sign a small estate affidavit. That's something that's allowed in a variety of states for property, typically either under 50 or under $100,000, again, depending on the state. Just a couple things to keep in mind with deceased tenants. It's not enough to have their will. It's not enough to have a power of attorney. It's not enough to have a death certificate. You're going to need the items I mentioned earlier. Those other items might well be interesting, worthwhile, etc., but on their own, they're not enough.
There we go. Nicole asks if we're wondering if we can email the lien letters rather than mail the letters with a certificate of mailing? Is there a way to have a message come back showing that the lien letter was received?
Yeah, so Melissa, or excuse me, not Nicole, sorry. That's getting into a couple of different issues. It's a software issue as much as it is anything else. I know there are some providers in the industry that I believe can help you with that. You're also going to want to look at your state lien law to figure out whether that requires some form of verification that the email has been received, or in California's case, I believe even proving that the email was opened. So you're going to, it very much varies from state to state. It's one of the frustrating things about email in a way. It can be great in a lot of ways, but there's a lot of different approaches from state to state. So you want to make sure that you've checked all those boxes. And then you also, again, not to belabor the point of the rental agreement, there are some states that require specific language in a rental agreement to send notice by email. So you're going to want to make sure that you're satisfying any of those requirements if they apply to you. But again, with all of these questions, please reach out to me if you want any more specifics at the email that we've put in the chat here.
Fantastic. The questions keep strolling in, y'all. So
Yeah.
here's what I propose. Melissa, maybe we have time for one or two more questions. And then what we'll do is we'll just collect all of the questions that have been submitted. Joe, I'll send them to you. And as you find appropriate, if you could, provide some sort of guidance one way or the other. But I'm just going to collect all of these questions and send them to you in a big email.
Great.
And that way we don't lose them.
Yeah.
So Melissa, you want to pick your favorite question and I'll pick my favorite question?
I'm going to ask one that I get asked all the time. This is by Christine. And then there's a follow-up from Caitlin. It's the very next one. Do we
Yes.
have to give photos, papers, etc., back to the client? And most of the time, they don't even get them from the auction buyer. And Caitlin says, how long do we need to keep these items once they are turned back in and still not picked up? I mean, I've had ashes brought in before from an auction buyer saying, here's grandma. I don't want to throw this away. Keep it. And then you try to contact the tenant for 6 months and no one ever calls back. What do you do with those things? Maybe not necessarily grandma, but what do you do with those important documents and photos and personal effects?
Yeah, so this is a tricky one. There are a few states that prevent you from selling that property, and you don't have a lien over it. So you're going to want to pay attention to your state lien law first off to see if you're in one of those handful of states. But beyond that, it's just kind of ultimately a discretion of the operator type of issue. And there's not a set time period you have to keep it. But you certainly want to be sensitive to those type of documents that don't have anything more than sentimental value attached to them. Specific to grandma and the urn, as creepy as this sounds, if you open up the urn, I actually talked somebody through this a couple of weeks ago. If you open up the urn, you can sometimes see whose remains, the name of the person whose remains are in there, and the crematorium or other service that funeral home that might have handled that. I would recommend just giving a call to them and saying, hey, I've got this. Is there something you recommend I do or that I can do if you're unable to get in touch with the tenant? But this is an area that it does persistently come up, and there's just a lot of just kind of trying to do everything you reasonably can, but there's not a clear legal direction on exactly what you're supposed to do in these cases.
There you have it. So, great question, y'all. Nicole, I saw your other question about different rates and so, those sort of things. I will follow up with you separately offline about the different rates showing on your website versus Sparefoot versus SiteLink and all those things. There are some ideas. There are some potential things that you can do related to that. So I'm scrolling through here. Let me see. I'm going to pick the last question from the Q&A. That I see some of these come up on Facebook, these Facebook groups as well. So I'm going to ask this one here. Jennifer says, how to collect from tenants that cause damage on the way in or on the way out. You know, we see the postings about someone drives a U-Haul truck, backs into your gate, or hits the side of your building. All of these things happen. What's the recourse and what can you actually do?
That man, that might be one of the hardest questions to answer, because there's just not an easy answer, that at least that I know of. You can typically say, first off, you're going to want to, again, make sure your rental agreement has the language you need in there to say that the tenant's responsible for any damage they cause to your property, to the facility, or importantly, to any other tenant's property, because that certainly comes up a lot as well. So first off, you want to make sure you have that language, at least to kind of as a gateway for you to continue to pursue this issue. Because if you don't have that language, the chances you're going to get anything are basically none. The chances, if you have the language, you at least have the gate open to you. Beyond that, it's a tricky issue. I would say talk to your, you want to first off make sure that you have your insurance appropriately to address these type of situations, because honestly, you can't get blood out of a stone, and a lot of times these tenants are not going to pay you. I'd also suggest taking a look and talking to your insurance agent to see if perhaps there's some insurance that you can make available to your tenants that would allow that would cover these type of damages. So there's tenant insurance, but that really covers damage to the tenant's own property or loss of that tenant's property. It doesn't cover these type of issues. And then I think the ultimate question people ask is, well, can I sell somebody's property in an auction if they do this and they don't pay me? You can, if you end up calling in your rental agreement any damage that's unpaid, if you identify that as rent. I would be very reluctant to go down that road with a tenant, and I would say the better course would be to just get rid of that tenant if they are a problem for you. Again, you kind of go through that process of non-renewal that we talked about earlier. But I would be really, really reluctant to say that this is somebody you can end up auctioning because of some damage they caused to your facility, even if your rental agreement allows you to do that.
Mm-hmm.
There we go. Proceed with caution. And again, I think it's probably what sounds like one of those nuanced things that it's a business decision, but also can consult with your counsel. But Jennifer, that's a great question. All right, my friend. So question of the week, Joe, before we wrap up and let you go back to your 5 beautiful children and their socks. What's the most important piece of legal advice you'd offer to a storage business owner?
Yeah, I think we've talked about the two that I would recommend. It's the association membership and making sure that you have an airtight rental agreement, whether you're getting that rental agreement through your state association or you're calling up a self-storage attorney to make sure that you have all of the provisions you're required to have, and then all of the ones maybe you're not required to have, but that are going to protect your multi-million-dollar asset. This is something, please do not go cheap on this.
I love it. We're in the self-storage business, and one of the beauties of it is it's relatively low regulation compared to some of the other industries that you could be in. And by following the lien laws and by joining your state associations, you can help keep us lowly regulated.
Right.
Yes.
Right.
Joe, Melissa and I always have the most fun with our guests, and you are one of the incredible dudes. So thank you so much, sir, for coming out and answering questions on the fly and coming with an agenda. That was awesome. Joe, I think email sounds like the best way for people to get a hold of you. Any other ways for people to chat with you or learn more about what you do or what the SSA does?
The other item I'd say, just take a look at our website, selfstorage.org. That's very easy to remember. I'm going to type my email in here one more time. But those are the best ways to learn about us. And then keep an eye on your email for our state and national events. next year. We're going to be at the Gaylord here, National Harbor, just outside of Washington for our spring event. And then back for our last year at the MGM Grand in Las Vegas next year before moving to the Aria for our 50th anniversary in 2025. So take a look at one of those national events. If those national events don't work for you, come to one of our state events or a state event at an affiliated state association.
Fantastic. Lots of great events having in 2024. There are a few more that wrap up the end of this year. I think I saw someone talk about Oklahoma's got a show, Michigan's got a show, North Carolina's got a show. So and Louisiana's got a show, and Tennessee's got
has one
a
too.
luncheon. Oh yeah, Alabama's got a show. So there's still some great networking and education opportunities in 2023 to close out the year. So be prepared for that. Of course, this show and all the past shows, along with other pop-up interviews, are available online, storagepug.com/resources. And we have a Gabfocus Self-Storage podcast. Check those out as well, wherever you listen to your podcast. And of course, there's a Facebook group, facebook.com/group/Gabfocus. That's where all of the friends and fans of Gabfocus hang out. And speaking of events, guess what? Our very first pop-up event has been scheduled. So if y'all remember, a few months ago,
finally got it on the calendar.
Finally got it down. If y'all remember, we had Nigel and we had Jackie, and we ended up talking about doors for 90 minutes. and we couldn't get enough talking about doors. So we're gonna bring them back for round 2 to talk about more about doors and facility upkeep and maintenance. So be ready for that. That's November 1st. Which is actually next week. So you'll get an email with more details on how to show up to that event. It's a little bit out of the norm of our regular programming. But then the next show of our normal programming is keeping your facility secure. So you've taken Joe's advice about how to keep you legally safe. We're going to talk about how to physically keep your facility safe. We've got 2 really awesome speakers for that one. That's November 16th, right before Thanksgiving. And of course, thank you, Joe. Thank you, audience. And Melissa, thank you for being my co-host.
Thank you. As always, this was great. Thank you so much, Joe.
Of course, yeah, a lot of fun. Looking forward to next year already.
I can't wait. I can't. Honestly, I was chatting with Melissa during I think next year we just come in and there's a live Q&A, no agenda. Come rapid fire questions because we could literally have spent 3 more hours just answering questions. So but much love, y'all. Enjoy the rest of the week, everyone, and we'll see y'all next week for the pop-up event. Joe, thank you, sir.